And speaking of due process, some more of the homework you sent me. This was going to be my vlog for today, but it was too complicated to do a vlog on while on Minister's Island with, I had a window of 10 minutes today to do a video. The Johnson & Johnson talc powder lawsuit, what do we call it? It's not a class action. It's not a joinder of actions, but a multiple defendant lawsuit. For anybody who doesn't know, Robert, it was in Mississippi, correct?
Yeah. So, there's two different parts to this. So the original big case was in Missouri. Johnson & Johnson lost their Supreme Court petition. And then this week, another suit was filed on behalf of a Black women's organization related to all of the findings that have already been made in these other court proceedings. So Johnson & Johnson was selling their baby powder, almost I remember it.
Yeah, it smelled great. I mean, everybody used it. And I remember reading the decisions, the articles coming out that they were sentenced to. At the time, the original jury condemnation was $4 billion.
That's right. It only got cut in half because the Missouri Court of Appeals said that there wasn't personal jurisdiction over all of the parties. There was for some of them. But it was still a $2 billion judgment, and they couldn't get the U.S. Supreme Court to take it up. And so, and then they have other cases against them as well across the country. But the interesting thing that added to it this week was the filing that reminded people that Johnson & Johnson, and again, Johnson & Johnson is a maker of a particular product right now, in some controversy, just a little reminder, as its other maybe relevance as to the trustworthiness of some of these companies that are making these products.
Robert, we all trust big tech now. It's quite clear. Big tech. We all trust big pharma, and you can't question it lest you get kicked off social media. So yes, we have we have paid a tithe to the big pharma overlords.
I would never distrust a company that's going to make billions of dollars and has zero risk of liability myself.
You made that connection. I did not yet make that connection because the only company I'm paying attention to on that front is Pfizer.
Right.
But you've poisoned my mind with that connection. But with
their particular product was in question from early on. But that's who this company is. I mean, one of the products sold is one of its safest, biggest products. Turned out it could give you ovarian cancer. So and we can say that now because the jury has already concluded that, and it's a final judgment.
And just so we're clear, talc powder. We're not talking about anything else. Baby powder, talc powder. This is the level of my neuroses. I'm so neurotic that even when I had, we put it on our kids' butts. I don't enjoy the idea of inhaling any fine particulate matter, regardless of what it is. I don't care. When you're smelling something, you're inhaling something. Someone's gas, you're inhaling it. Talc and these what they call hydrophobic powders, I don't like inhaling them. So I never liked inhaling baby powder. I never liked using it. But the bottom line, I read the judgment. The judgment was not the judgment, rather the motion for cert or the request for cert. It was very well drafted. It was very compelling because you do appreciate, as Johnson & Johnson alleges, regardless of whether or not you hate them, that you're in a situation where plaintiffs have gotten very good at, it's not forum shopping even right now, it's plaintiff shopping. They go around and look for people who fit certain criteria. And when you're dealing with 350 million people and talc powder, which has been sold to pretty much, let's just say, half of the country, you're going to find, if it's not connected illness, at the very least, coincidental illness at a large enough scale that you can file suit and draw some correlation to. So bottom line, it is alleged in the petition for cert that was denied, I guess, that these plaintiffs went looking around for people who used talc powder and subsequently developed cancer and ovarian cancer. And they lumped them together in lawsuits and then brought the suit in a jurisdiction that they felt was favorable, even if a number of the plaintiffs were outside of that jurisdiction. And even if the plaintiffs themselves had different illnesses or different degrees of illness, different degrees of remission or cure, some died, some got better, different damages, everything was different, except they lumped them together in one jury trial and then instructed the jury to treat all of these individuals as different plaintiffs and not as one lump plaintiff. And what I found most shocking was that apparently the jury instructions lasted 5 hours in this case. So for 5 hours, they're instructing the jury on different jurisdiction of law. they're instructing the jury on, don't treat these defendants as equal. You have to treat them all as individual defendants, even though you're called to adjudicate on it effectively in one big judgment. Some of the plaintiffs suffered different illnesses, different degrees. Some of them didn't even use the product, but had, it's alleged they had dreams of having used the product. And then the jury comes down with magically the same monetary damages for all the plaintiffs and a punitive damage which apparently exceeded the ratio of punitive to monetary damages. So, look, that's the broad overview. It's complicated. I hope that does it justice. But Robert, explain the first thing. What is under the law in the United States the principle of law as relates to punitive damages ratioed to monetary damages?
Well, I mean, in my view, there shouldn't be any ratio, but the U.S. Supreme Court has said there is. Justice Breyer famously said it's a rule of thumb, which I found ridiculous. But that's our Supreme Court standard. Maybe it's excessive, maybe it's not. And it just depends on whether the Supreme Court is personally offended, frankly, as to whether they take the case or not. But basically there has to be some proportionality. You can only look at harm done within that state. For example, you can't look at harm done outside of the state if it's a state court proceeding, things like that. And here the amount of damages collectively was about $550 million, $25 million each across 21 different plaintiffs. And then they did about $3.5 billion, which is about basically if you're under 10-1, you're going to be okay for review. Unless now I have come up with creative facts. My view is don't analogize it to monetary damages, analogize it to criminal punishment and penalty, and compare it to gross revenues of the entity. So if somebody could serve 5 years in prison for this, then give me 5-year profits for it. That should be, if we're going to treat our criminal punishment system comparable to our civil punitive damages system, that's the comparison we should be making. They don't like that because there's only one group of people really worried about punitive damages of a big size, and that's big corporations who get caught doing something bad. And that's why the courts are eager to, we got to have some due process here. We can put grandma away for 6 months while we can't get a trial for her on January 6th. But by golly, that big corporation, poor BMW, they didn't mean to screw that up on the paint. That kind of reality. But they basically lost that side. But with the undertold story, now people can question some of the lawyers involved with the new suit. But it is a known fact. They particularly targeted African-American women for this product. So they basically, and were disproportionately, and what hurt them was usually these kind of toxic tort cases are very hard to prove causation. They usually do a good job, the corporate lawyers, at getting the cases severed, making you do the liability in one side, damages in another, so the jury never hears the sob story, all that. People can watch a really good film or read a really good book called A Civil Action to show you how tough toxic tort cases are. That's in the environmental context. We'll be having no sidebar this week, but a sidebar next week with Bobby Kennedy, who did a lot of, has had huge success. And it may be why he went from, environmental tort, toxic tort, to dealing with big pharma and the vaccine and other contexts. People didn't realize there's actually maybe there's a logical connection once you understand what some of these companies are up to. But it's an interesting suit, and it's interesting the media has not talked about it much, given the political people involved, given the clear racial discrimination that took place. I mean, the thing that hurt Johnson & Johnson was that through the 70s and 80s, they knew this, and they hid it. They hid it from governments, they hid it from regulators, and obviously, most importantly, hid it from consumers. They had spotted the problem with their product causing cancer in one of their most mass-marketed products, and they just, hide and lied. And that's why that jury didn't care about differences between plaintiffs, different stories. They were going to whack Johnson & Johnson, and in my view, deservedly so. But this new suit exposes a new problem of big corporate America targeting and discriminating against particular groups for their product in particular, causing cancer, mass cancer, and for African-American women especially.
So, Robert, I read the motion for cert. It admittedly, obviously, it's drafted by J&J's lawyers, and they raise some good points. When you sell a product to, let's just say it reaches 150 million people get cancer, people get ovarian cancer, people get all sorts of illnesses. What evidence? I mean, do you know? Are we aware of what evidence was adduced to actually, prove the causal connection between the talc powder and the type of cancer at issue? Because from the cert, it sounds like there was no evidence. Obviously they're straw manning probably the plaintiff side, but what was any evidence that there was a correlation between the talc powder and ovarian cancer?
There were two different things. And by the way, the lawyers who wrote that cert petition are famous liberal Democrats, by the way. So it tells you where they really are. Neil Katyal and some other big names on that group. It's a reminder, you're in the African American community, who really is on your side. But they had 30 experts, is my recollection. There was a 3-week trial that testified, and the key thing again was their own internal documents. It was Johnson & Johnson's own people flagged, oh, this looks like this causes cancer. Well, what do? Keep selling. That's what they did. And what is they went up against some very tough plaintiffs' lawyers, because plaintiffs' lawyers learned from the big tobacco suits how to hold people responsible. And one of the keys was joinder, forum shopping, pick the right jury pool, pick the right judge, pick the right county, pick the right state, and all the rest. And the real reason I think neither the Missouri Supreme Court nor the U.S. Supreme Court would get involved is because when you see that Johnson & Johnson knew about it in the 70s and 80s, your sympathy kind of goes out the door, even if they had some technical claims that had credence to them.
Okay, I mean, that is where it's damned by your own documents that people can have a very tough time contradicting. So I read the second was a motion. It was it's a black. I don't know if it's a black rights group who's suing, but it was clearly
national. I think it's National Black Women's Organization or something of that effect.
So now here's the question. It's another ignorant question from someone who doesn't know better. I mean, how does Johnson & Johnson, or how does any company target a specific demographic for advertising or for a product? Like, what does that mean?
Marketing. It's in marketing and distribution. Where you distribute it, where you market it. Big Tobacco was infamous for this. So and in fact, drug companies do it in general. Arguably opioids targeted poor working class whites and rundown communities, as an example. Which counties, which cities, where they advertise, how they advertise, to whom they advertise. You can buy ads specifically for, I want black mothers between the ages of 35 and 55. I want white grandmas between 75 and 90, whatever, because all those demographics are available through Nielsen ratings and the rest. Political campaigns do it all the time. And so they both targeted them in their advertising and they targeted them in their distribution. Which stores you put it in, which stores you cut a deal with to promote it, all that kind of thing. And so which doctors you cut deals with to pitch it. And the other utility to this is, like I said, it might be a preview or it might be a reminder of how these particular companies operate given the current space they're operating in. And how if they would lie about this for decades, wouldn't they lie about something they can't be sued over?
Now, Robert, but you're talking about unknowns that we don't know about. And right now, all we know is that what we're being told by a government that changes its tune literally every month. And I'm not saying that to be contrarian. Who was it? I posted something on Twitter where Biden is now saying, when I said the thing about the masks before, it was true at the time. If the science and the directives change this much from one month to the next, turn that light back on. We're being led and governed by I won't say fools, but by people whose opinions change from one month to the next, and that's fundamentally unreliable governance. Okay, so the petition for cert was denied. So Johnson & Johnson is stuck with what was halved was the $1.5 billion judgment.
It's a little over $2 billion now. So they're writing some big checks. And now they got exposed on this other side. We'll see how that develops. But it's both preamble to what may be going on right now, warning at least to what may be going on right now, and it's a reminder of who these companies are. And it was a good win for the plaintiffs to hold Johnson & Johnson responsible. And this new suit is a reminder of their particular targeting. Like, for example, the Biden administration is flummoxed at why certain people are not interested in a currently distributed medical product from Big Pharma by particular constituencies and communities. And it's not based on party, it's based on other narrative histories. But this case might be a reminder of why that is the case. And what's interesting is the remedy they're seeking, what they're asking for is something specific. They're not looking for monetary damages. They want Johnson & Johnson to advertise to really the whole world, but definitely to African-American women through all available means and marketing that they used to sell their product in the first place to them, to tell them, by the way, we lied to you and it causes this harm potentially, which I'm sure Johnson & Johnson doesn't want to do. But it was an interesting suit that seeks a very unique, specific remedy.
All right, and the denial of cert was it a short judgment? I didn't read it. Was it a one pager or just a one liner?
It's one sentence when they deny cert. It's just one sentence.
Now, finish up on this one for the Johnson & Johnson. They raised an argument which I thought was interesting, but almost hypocritical is not the right word. They said if the courts sanction these multi-billion-dollar punitive damages, it's going to bankrupt the companies and frustrate the company's abilities to actually right the wrong, to remedy financially the harm, because they'll go out of business and then the plaintiffs are going to be left without a company to pay them their settlement. I mean, it's an interesting argument. It's sort of like saying, let us continue making money off our wrongs so that we can pay the people who have been wronged from our wrongs. I mean, asking the obvious question, what's your take on that argument? And what do you say when they say, like, yeah, the asbestos companies are all out and people are screwed with cancer now and have no remedy because of the amount of the judgments? What's the retort to that?
The general retort is that in terms of damages, they can set up a fund like the asbestos companies did to make sure people are compensated for their injuries. And if you get a punitive damage award that leads to your bankruptcy, then that's a jury's determination that that's an appropriate thing, because they take into consideration what your revenues are. Now, Johnson & Johnson is at no risk of bankruptcy. This is a hit, but it's by no means a mortal one. Again, this company was one of the prominent companies pushing the current new product. So keep that in mind.
And now we got someone who takes issue with you referring to black people as African-American. I don't know if it's a troll. I don't know if it's intended to be sarcastic humor. The reality is, Hydra P, at some point, we all have to use the terms that people are saying are the correct terms. I referred to the Aboriginal community as Aboriginal in the video, and someone says, Viva, you're going to get in trouble. That's no longer the right word. It's Indigenous. We use the term. If anyone is suspecting anyone of ill intent, racism, or whatever in our circle of YouTube and social media, you're in the wrong place to be making those accusations. I know the way Robert's using it. It is not ill intent whatsoever. And so we can end it there. But thank you for the super chat.